faculty, and I'm absolutely delighted to welcome you here this evening to a conjoint exercise between the Faculty of Law and the Australian Institute of International Affairs. And we are absolutely delighted and privileged to have one of our own here to address us this evening. You'll see that the title is Tales from the Hague, Professor Tim McCormack. And I don't know if tales there are tall tales, Tim, or whether we're talking about something which is maybe a touch more realistic. But
could be a bit of vertical exaggeration.
Slight exaggeration. I just did wonder that choice of the word tales. Yeah. So it's great to see such a good group of people to come and join us this evening. Now, as is our custom, we engage in acknowledgement of country at the outset, and I'd like to acknowledge as a consequence that we're meeting in Little Wita, Tasmania, Aboriginal land, sea and waterways. And with that we acknowledge with deep respect the owners of the land that we are located on this evening, the Muwinina people. And we know that the Muwinina people form part of a culture that goes back thousands of years and involves the caring and protection of country. And we know that even though sometimes we focus very much on the present, it's a privilege for us to stand on country in the footsteps of those who've come before us, not just last year, not just a decade ago, but thousands of years ago. And to that end, we pay our respects to the elders of the Muwinina people, those in the past, those in the present, and those to come. We also acknowledge those who have not reached elder status. I recognise to that end a history that acknowledges that the impacts of colonisation and dispossession have been severe and heinous. And so with that, even though we can't change the past, we can stand for making a positive change in the future. A future that respects and acknowledges Indigenous perspectives, culture, language and history. And with that, supports reconciliation to pave a more positive future. And with that as a backdrop, and I know Tim feels very passionately about what we've just spoken about, but he also is very passionate about international criminal law. And I've got to say, Tim has made his mark internationally in that field. And when I say made his mark, he's still making it. I'm not saying just in the past, he's still going in that regard, and this is part of the exercise this evening. And I'm very proud that Tim is a member of the academic staff and professor here at the law school at the university. And I know he's very proud to be an alumnus of the University of Tasmania, and we are equally proud that he is one of our alumnus. And so I mentioned that he's going to be speaking about Tales from the Hague in view of his position, as many of you know, as Special Advisor to the Chief Prosecutor at the International Criminal Court. And Tim has had a residency there recently from the months of April through to June. And so no doubt he's been at the pointy end, or seen the pointy end of what the ICC is up to at present, and might be in a position to indicate where he sees the future heading in that regard. So I take this opportunity to welcome Tim to come and join us here on the stage. Tim will take questions at the end. There will be an opportunity for, say, 15 minutes of questions. And so I'm absolutely delighted to welcome Tim through. Thank you, Tim. If we can welcome
Thanks very much, Gino, and I appreciate both the introduction as well as the acknowledgement of the traditional owners and the custodians of the land we meet on. Thanks to all of you for coming out. It'd be a paltry experience if no one rocked up, wouldn't it? And there are some very special people amongst us. My mother, Patricia, and three of my four brothers. They're also members of Gabby Gee's extended family. Some colleagues that I work very closely with on the subject matter of international criminal law, Matt and Reggie in particular, members of the International Law Discussion Group, Matthias as a previous Tim Hawkins Scholar, many students, some of whom, having attended the recent summer school, ought to be able to give selected parts of this presentation, except they haven't been in the Hague with me, so they can't. Phew. And some colleagues of mine, I really appreciate those of you who've come. It's a great gesture of your collegiality, and thank you very much. I have, as Gino said, just spent 2 months in the Hague, and I've never done that in terms of the length of the time at the International Criminal Court for the 13 years and now 4 months that I've been Special Advisor on War Crimes to the Prosecutor of the International Criminal Court. The most I've ever spent in all that time has been 2 weeks. Just over 12 months ago, not long after Russia invaded Ukraine, I had a conversation by Microsoft Teams with the Prosecutor of the International Criminal Court and told him how frustrating it was to be his Special Advisor on War Crimes. And at the moment in time of the greatest war crimes challenge to the International Criminal Court, not because of Russia's invasion of Ukraine and the allegations on a daily basis of war crimes occurring, not to be more engaged in the work of the Office of the Prosecutor. He interpreted that opening statement as my desire for a job, and so offered to appoint me as his special legal advisor at a certain level of seniority, which was quite flattering. And I said, no, I'm not after a job in the Hague. I don't want to move to live in the Hague. I live in paradise, mate. You've got to understand. What do you want? I want to come for an extended period of time. Oh, but I can't. All the special advisors, there are now 30 of us. We have proliferated like the proverbial rabbits, all with different portfolios. But all the special advisors pro bono, I can't afford to pay you a salary. I said, I don't need a salary. I've got so much accrued leave at the University of Tasmania that I've been threatened to have it taken off me if I don't use it up. I'll gladly use some of it to come for an extended period of time. But what I do need some help with is the costs, the travel costs, the airfare, the living expenses, the accommodation costs. Well, I could possibly dip into the trust fund to apply for permission to... I said, don't do that. Write to the Australian government. Well, my suggestion is you do that and ask them if, as part of their contribution to supporting the investigation of alleged war crimes in Ukraine, they make this contribution in the broad scheme of things, compared to donating 30 new Bushmasters or sending thousands of artillery shells to Ukraine. From a Ukrainian perspective, I'd say they're more important. But this is a relatively small financial cost. He did that, and it took him a while, but in the end, DFAT came good. And so Karen and I were both able to go for that protracted period of time. And it was a wonderful experience. For me, I'd become increasingly concerned that as a consequence of a 3-year hiatus brought about by the dreaded global pox, I was unable to travel to The Hague, and last year in November was the first time in 3 years, since November 2019, that I've been able to go. And in that time, with no Tim Hawkins Scholar on the ground at the court in The Hague, it became increasingly difficult to stay engaged with the teams. Now that's all been rectified, I'm happy to say, and Gabby, who is our current Tim Hawkins Scholar, is, let's say, inundated with the amount of work that she has to do. More of that in due course. I really want to talk about a few different things. First of all, sort of where we're at the moment in the experience of the court, and particularly 2 key decisions that we're waiting for, and I'll explain a little bit about what they are. Then I want to talk some more about the teams that Gabby and I were working with while I was there for 2 months, and some of the issues that have, some of the international humanitarian war crimes issues that have come out of those engagements with the various teams. And then to make some more general observations about where the court is at and the likely prospects for the short to medium term, not the long term, being neither a prophet or the son of a prophet. I won't get assessments, and that's partly because it wasn't that long ago that I was making some of my own analysis of how I thought the future would be, and they proved to be spectacularly wrong, so why would I engage in that sort of activity again? There are two key decisions that we're waiting on from the judges of the court at the moment. One of them is judgment in a trial that's recently concluded against the second individual accused from the conflict situation in Mali. The accused surname is Al-Hassan. The first Mali national to be convicted by the ICC is a guy called Al-Mahdi, who was the first person in the history of the court's jurisprudence to plead guilty. And he pled guilty in relation to a count, or a couple of counts, of the war crime of intentionally directing an attack against cultural property. Some of you will know the facts in Timbuktu, others of you won't. Let me assure you that despite my childhood experience of believing that Timbuktu was somehow or other some fictional place from here to Timbuktu, it's real. It is a city in the north of Mali, has this fascinating history as a major trade route from the north of Africa and the Fertile Crescent down to sub-Saharan fertile southern Africa, and became a massive centre for Islamic learning and teaching. Libraries, Islamic schools there, an incredibly vibrant place. And as a consequence, it has profoundly significant Islamic structures, mud brick mausoleums, shrines to Islamic saints, libraries, and schools of learning. All of them UNESCO World Heritage listed. The more you experience of UNESCO World Heritage listed sites, whether they're natural or whether they're built, you understand that that listing doesn't happen for no reason. And the mud brick structures in Mali, in Timbuktu, are another example. Some Islamic fundamentalist groups, particularly Ansardin and also Aqim, or the abbreviation AQIM, two non-state armed groups, took control of Timbuktu and much of northern Mali, and we've had a civil war going on there for several years between the government forces who control area in the south, including the capital, Bamako, but not in the north. And these particular groups have taken a specific approach to their understanding of Sharia law, which is a very strict and thoroughly theologically conservative view of what Sharia law means. One consequence of all of that is that they engaged in destruction of the mausoleums, UNESCO World Heritage listed shrines and mausoleums to Islamic saints. You could be forgiven for thinking, why would Islamists be engaged in the conduct of smashing up shrines and mausoleums to Islamic saints? Because from their perspective, these were detracting from veneration of the Prophet and of Allah. Now, Al-Mahdi pleaded guilty to counts of the war crime of intentionally directing attacks against those sites. It helped that there was French media video footage of him and several others whaling into some of these sites with sledgehammers. And so he really decided he didn't have much choice, better to plead guilty. So the process of confirming the conviction and awarding the sentence was quite brief and relatively uncomplicated. Al-Hassan has never pleaded not guilty, and instead his trial's gone on for several years, and the concluding submissions to the trial were conducted while in the first weeks of my stay in The Hague. The reason why this case is very important for us in the prosecution and for followers of the jurisprudence of the International Criminal Court is because there are two charges that have never been laid before that we are now waiting for judgment from the trial chamber in relation to. One of those is Article 2C4. I could ask my students from summer school to please recite the provision, but it's various colloquial expressions to describe it, a little bit uneasy about that. It is the war crime of passing sentences and judgments by other than a regularly constituted court. Very interesting provision in the Rome Statute. It applies in the context of non-international armed conflicts. It's a serious violation of Article 3, common to all four Geneva Conventions of 1949 and codified in the Rome Statute. We have never had a case decided by any international criminal tribunal on what this war crime really means. The allegations of fact in this case are that Unsadin set up so-called tribunals, courts that sat in public, that heard the case against the accused, that never gave the accused the right of defence, never gave the accused the right of legal representation, didn't give them the right to defend themselves, no right of appeal, sentences handed out and summarily imposed. Some of them public floggings, some of them amputation, some of them execution. Pretty serious stuff. And we're trying to work out, we've asked the court to decide that what happened here constituted the war crime. One of the reasons for mentioning it is, apart from the novelty of it, I hadn't checked this with Matthias earlier, but I'm sure he won't mind because it's all praise, not slagging off. Matthias, while he was a previous Tim Hawkins Scholar, spent a great deal of time working on researching what this war crime means, and we, between us, made submissions to the Mali trial team several times in relation to it. Matthias then used this case study as a core case study in the development of his PhD thesis, which was examined, it happens, by a professor in Stockholm, Professor of International Criminal Law at the University of Stockholm Law School, who then wanted to use some of Matthias's development of his arguments in the thesis to support the defence team in Al-Hassan. I don't know whether he actually ended up doing that or not. We'll know when we see the judgment, because there will be references to his thesis or there won't. But from my perspective, when the history of the Tim Hawkins Scholarship is written, there will be examples of profound contributions to the development of international criminal law and the law of war crimes. And many of those will be as a consequence of the work of some of our graduates. This is a wonderful story waiting to be told in its detail. The second war crime that we're really interested in because of its novelty, it's actually not a war crime, it's the crime against humanity of persecution on the grounds of gender. Gender persecution, what does that actually mean? It means that the deliberate targeting of a victim group because of their gender may often, perhaps in most cases, be women, it might be children, might be men, it might be members of the LGBTQIA community, some minority group that's being targeted on the basis of its gender. And the allegation in this case is that women were specifically targeted by members of Unsadin and ACAM in relation to things like immodestly dressed in public, holding hands in public, not being accompanied by a responsible adult male in public, and as a consequence often publicly flogged, in some cases executed. It's a horrendous story, and that crime has been charged for the first time, and we're waiting with bated breath to see what the trial chamber has to say about it. A second very important decision that we're waiting on is not a judgment in a trial that's just concluded. Instead, it's a decision by the pre-trial chamber. The ICC has three separate chambers: a pre-trial chamber, a trial chamber, and an appeals chamber. There are 18 judges, and those judges are split across the chambers. The pre-trial chamber decides preliminary matters to a trial proceeding, and those preliminary matters include things like the approval of the issuance of an arrest warrant against an accused, or the confirmation of charges against an accused. In February of 2023, the prosecution requested a decision by the pre-trial chamber to allow or to approve the conduct of what we call the confirmation of charges against Joseph Kony, the accused leader of the Lord's Resistance Army in northern Uganda. Some of you remember that way back in 2005, the pre-trial chamber issued an arrest warrant against Joseph Kony. He's never been found and taken into physical custody and transferred to the Hague. The ICC has no authority to conduct a trial against an accused in absentia. The court has to have physical custody of the accused before it's able to proceed to trial. But this preliminary stage, which we call, or the Rome Statute in Article 61 calls the confirmation of charges, is akin to those Australian jurisdictions that have what is called a committal proceeding prior to criminal trial. It's a preliminary proceeding where at the ICC the prosecution has to prove substantial grounds for believing that this individual accused is criminally responsible for these offences. Now, Article 61, paragraph 2 of the Rome Statute specifies that the prosecution can request the pre-trial chamber for approval to conduct that proceeding in the absence of the accused in exceptional circumstances. The Office of the Prosecutor has made that request of the pre-trial chamber, and we're waiting for a decision, and we hope we get a positive one. Although I'd be fascinated to know from your perspective, Reggie, as member of, or an approved member of the Defence Council, what you would think about that. I know that the Office of the Public Defence Council has made submissions about that request from a prosecution perspective. This is a really important precedent if the pre-trial chamber approves it, because the prosecutor has said publicly that he intends to make that same request in respect of the arrest warrant against Vladimir Putin. No, there are no immediate or even medium-term prospects of Vladimir Putin or Maria Lvova-Bulova, the other named accused in the arrest warrants issued earlier in the year, of them being taken into physical custody. So the question is whether the pre-trial chamber would approve that proceeding, the confirmation of charges, to happen in the absence of either of those two key Russian leaders, one of them obviously way more senior than the other. The incumbent president of a permanent member of the Security Council. Incredible development at the International Criminal Court. Let me move to Gabby and Tim. What a team we were for 2 months. Gabby left Tasmania in February and started at the court within 10 days of arriving there. She'll be there until November, when her successor, Chun Yu, also a graduate from this university, takes over as the Tim Hawkins Scholar. I plan to go back because we're having a 2-week handover period. I've always considered 2023 a critical year for us. I mean me and the Tim Hawkins Scholars, to re-engage with the trial teams at the International Criminal Court after all that COVID did to disrupt that. And so that's one reason for wanting to spend extended time there, and also a reason why I was very keen that this time, unlike in past times, we don't have any hiatus between the current Tim Hawkins Scholar and the successor. Let's make it continuous. Chun will be there for the first 2 weeks of November, as will I, and the Troika will get into it. But Gabby and Tim had a great time together. She's doing a terrific job. And I'm delighted that having had this period of time for me, an unprecedented extended time, now Gabby and I can follow up on that way more easily as a consequence of me being there. Gabby did say to me at one stage, a few weeks in, is it always this intense when you're here? I said, Gabby, you got no idea. I said, this is like we're operating at 70%. I said, when I'm normally here for a week and a half or 2 weeks, it's way more intense. But it's slightly more relaxed because I'm very conscious of the fact that it doesn't have to happen this week. It could happen next week or the week after. Never been in that position before. He said, really? I said, yeah, don't worry about it. It's all good. Once I'm gone, the tropical cyclone will cease and you'll have time to prioritise what you need to do and work at a slightly less intense pace. There was a great moment in the court. So, you can't label this Tales of the Hague and only talk substantive content. At one moment, one of the investigators in the Office of the Prosecutor, who shall remain unnamed, but let's say he's of British origin, says to me as we cross in the corridor, one of the joys of being there for an extended period of time is the opportunity for spontaneous conversation in the corridors, at the tea-making machine, in the cafeteria, wherever. We come across each other and he says to me, he said, I've just been in a meeting. Honestly, they were talking about you like you were Jesus himself. Tim McCormack's coming to meet with us next week and he's going to sort out our issues for us. And I said to them, look, I'm actually pretty sure he's just an ordinary bloke who's doing a good job. And I said to him, let's listen, why don't I start off the meeting when we meet next week by saying, I'm not the Messiah, I'm just a naughty boy. And anyway, Jesus is actually my younger brother, to whom the crowds flock on Thursdays when he's here in Hague, rather than his normal place of residence in Bendigo. You've got it all wrong, fellas. A little bit more seriously, Gabby and I have been working with all the teams dealing with situations of armed conflict and allegations of war crimes. And I can give you the list of those without disclosing any of the confidentialities. The Palestine team, the Afghanistan team, the Darfur, the Uganda, the Democratic Republic of Congo, the Central African Republic, and the Georgia teams, and of course, the Ukraine team. I was physically placed, in terms of my office space, on the floor of the Ukraine team. They occupy an entire floor of the building because there are heaps of them. That was very convenient and also appropriate. I had more to do with the Ukraine team because there's more of them and there's a greater level of activity going on with the lawyers, with the investigators and with the analysts, the military analysts, the data analysts, a whole stack of analysts. I had daily interactions with them, spontaneously in the corridors. I met with the team leader at least twice a week, except when she was on mission in Ukraine, which happened twice while I was there. And with the trial lawyers at least weekly. There were a couple of weeks where it was a little bit more frenetic than that. With the rest of the trial teams, it was as and when required. And one observation I would make is that it never ceases to amaze me how factual situations that we're dealing with raise new or novel legal issues. I'm sure for Sir Guy Green, for example, former Chief Justice of the Supreme Court, that's not a new concept to judges, because that's part of the fascination of how the law develops. But for me, I find it absolutely intriguing. I think I know what I'm talking about in relation to a particular provision of the Geneva Conventions or the additional protocols or the Rome Statute, at least in terms of Article 8 that codifies the list of war crimes over which the court has jurisdiction. But no, there's this fascination about the fact that this issue's never been decided before. And I mean, I could perhaps give you a couple of examples without disclosing the situation in which the issue arises, just as a taster of what I'm talking about. In relation to the war crime of child soldiers, for example, which is a war crime in both Article 8.2b, in the context of international armed conflicts, and 8.2e, in the context of non-international armed conflicts. All my students from summer school know exactly what we're talking about. The rest of you, please accept that that's the way that it is. The war crime of child soldiering makes it a crime conscript or enlist, we're distinguishing between forced recruitment or voluntary recruitment, if there is such a thing as someone under 15 years of age being able to give valid consent to their being brought into an armed group, children under 15 into armed groups. The rationale here is that this conduct is criminal because those children under 15 years of age have lost their childhood innocence and are now exposed to the possibility of being legitimate military targets by the opposing side, as well as any trauma that might be imposed upon them as a consequence of them participating in the hostilities. Now, the question is, that this particular question, I couldn't answer it. How long, in terms of time, is the minimum to be able to say that a child under 15 has been conscripted or recruited, enlisted, into the armed forces? Can it be a few hours, an afternoon, a day, or does it have to be something longer than that? Oh, fascinating, I don't know. Let's find out. What about, when does the armed conflict actually end? When does the law of armed conflict cease to apply? When in the context of an armed conflict, one side wins, the other side is defeated, and perhaps to throw some granularity into that question, where part of the defeated side withdraws from the conflict, and the remaining part of the defeated side continues to conduct hostilities, although with significantly less intensity because of the depletion that results from the withdrawal. The reason why that's an important question is because we can't charge war crimes anymore once the armed conflict is over. So we're talking about where the parameters, the temporal parameters end in relation to the period of time for the prosecution or for the charging of war crimes. What about in relation to the issuance by the UN Security Council of a referral by the Council to the Prosecutor of the International Criminal Court? Here I have to disclose the situation because there have only been two of them. Darfur in 2005 and Libya in 2011. Neither Sudan nor Libya were or are or ever have been states parties to the Rome Statute, but the UN Security Council has the authority to override that issue, which is normally a requirement for the court's jurisdiction, and say we can refer non-state parties. The Security Council did that in relation to both countries. The question is, does that mandate, that referral by the Security Council, which gives to the court jurisdiction over those two situations, continue to the present day? I mean, we all know from the media that the fighting in Sudan has been appalling in the last 6 to 12 months. Is the contemporary conflict in Sudan, at least in the Darfur region, because it's been going on there, as well as Khartoum and other places in the country, but certainly in relation to the Darfur situation, does that 2005 referral persist or not? It's also an issue in Libya. Can't answer it because I can't tell you what we think about that, but that's the question. Another one, briefly, for a UN peacekeeping mission set up by the UN Security Council, deployed into a country in which the court has jurisdiction, is that peacekeeping mission entitled to civilian status and therefore immunity from attack by the parties to the armed conflict? Or is it a party to the conflict, and how do you determine that? We've got some jurisprudence in the past about what the criteria are for determining whether a peacekeeping mission is entitled to protected civilian status or not. But we have a factual situation that raises a novel issue that's never been decided, and we're grappling with that. That's as far as I can go with that one. Needless to say, Gabby's got plenty to do, and I she and I are speaking every week by WhatsApp, slightly more secure than by Zoom or Microsoft Teams, but we do speak in code from time to time. We don't mention country situations. We're really careful about the substance of what we discuss. But I'm trying to assure her that she mustn't feel overwhelmed. She's, as far as the court's concerned, is a volunteer. She does what she can, and leave the rest to Chun, who'll be there in a few months' time, and let's give her some work to do. All right. Let me make a few general observations, and then I'd really like to open it up to questions. And I'll try not to rave on too much here so that I don't cut the question time short. The Ukraine team is stacked with resources in relative terms. There has never been a trial team as well resourced as the Ukraine team. And by well resourced, I'm really talking about human resources, because what's happened is that states parties to the Rome Statute have almost literally fallen over themselves to second experts, to second trial lawyers, to second investigators, to second analysts. And that's fascinating, and in my view, welcome, because it means that the Ukraine team, which has massive challenges in terms of the scale of atrocities and Rome Statute offences, is actually able to make good progress by ICC standards. But it does also create a huge disparity, because no other team is resourced like that. And for me, that's deeply problematic. I think about the Palestine team, the Afghanistan team, plenty of other situations where if states parties saw the precedent of what's happened in relation to Ukraine and were prepared to make a similar sort of commitment to second experts for 12 months or possibly 2 years or even longer to those other teams dealing with other situations, that would be an enormous contribution to the work of the court. Second observation is that security, and here I'm really talking about security of information, possibly also of personnel, has become a bigger issue after Russia's invasion of Ukraine than it ever was before. I've been thinking about this a lot because 10 years ago or longer, when the court was dealing with Uganda, Democratic Republic of the Congo, the Central African Republic, we could have a pretty open conversation. And if I think, for example, Matthias, about sort of the things you and I were able to talk about over Zoom or Skype we might have used back then, we were not constrained. We didn't have to really think about it. Now, there's no way Gabby and I can have conversations like that. We have to assume that everything that's said virtually, digitally, is being listened to. And that's interesting in terms of what that means at the court itself when I'm meeting with the Ukraine team or the Palestine team or any individuals from them. No phones, no smartwatches, no devices in the room. Otherwise, we can be listened to. And I'm really fascinated by the changes that that's making in terms of how the court and the Office of the Prosecutor does its business. There are some positives because the information explosion and the capacity of it has also changed how we investigate. One very good example by the prosecutor's new security advisory Office of the Prosecutor is that we now can prove that the Russians intended to invade Ukraine weeks before the invasion actually occurred without interviewing a single witness, because satellites tracked the massive transfer of blood and plasma products to the front line weeks before the invasion happened. You do not transfer those amounts of plasma products if all you're engaged in is military exercises. So yeah, I'm fascinated by the whole information explosion. A couple more quick observations. The International Criminal Court's riding a halcyon wave of unprecedented support, and 3 years ago I wondered seriously about the medium to longer term future of the institution. The Trump administration wanted to blow the thing up, the thing as in the institution of the court. They were so opposed to the ICC, primarily because the prosecutor dared to open a formal criminal investigation into the Afghanistan situation and, rightly in my view, claim that she would look not only at the conduct of the Taliban and its coalition forces, but also at Afghani government forces, where the Taliban was in opposition, and coalition forces. And that meant the United States of America. And they were not happy about that. Now, all of a sudden, the Biden administration is, I wouldn't say the number one ticket holder of the fan club of the ICC, certainly not willing to become state parties, but they've actually passed legislation permitting US government agencies to cooperate with the court. This is unthinkable 3-5 years ago. This is all about Ukraine, and here's the discomfort. It's Russia we're after, but we won't subject ourselves to the jurisdiction of the court. The Australian government is engaged in discussions at the moment with a whole range of other countries about the possibility of establishing a special tribunal, ad hoc, one-off, to deal with the crime of aggression against Russia for its invasion of Ukraine, because the International Criminal Court does not have jurisdiction over that situation. We're prepared to do that, while at the same time refusing to sign up to the amendments to the Rome Statute to accept the court's jurisdiction in respect of the crime of aggression. There's a bit of hypocrisy going on, and I can assure you, just in case you're thinking about why would you slag off at your major sponsor just till we get to the court? We're not alone in the world on that one. But on a more positive note, while there is a fickleness to all of that, there is a positive story. So, and now but. Here, the existence of the International Criminal Court, with its jurisdiction over the Afghanistan situation, and therefore the spectre of the ICC, the possibility that the ICC may turn its gaze, sounds like Sauron, doesn't it, in Lord of the Rings, turn its gaze to the coalition forces and their conduct. All of a sudden, New Zealand, Australia, and now the United Kingdom are taking more seriously the national investigation of alleged war crimes by their own armed forces. The New Zealanders went through a process of an independent inquiry into the so-called Operation Burnham, with allegations against New Zealand Special Forces conducting war crimes in New Zealand. We, as you know, have been through a 4-year process of the Brereton inquiry, and now a formal criminal investigation by the Office of the Special Investigator into alleged ADF Special Forces war crimes in Afghanistan. And the British government has established a new independent inquiry into Afghanistan that's looking at allegations of UK Special Forces war crimes in Afghanistan. In all 3 cases, both in relation to the report of Operation Burnham, Major General Brereton's report, public statements by Mark Weinberg, the Special Investigator heading up Australia's OSI, and by Sir Charles Haddon Cave. I should say the Right Honourable Lord Justice Sir Charles Haddon Cave. Here's a tale from the Hague. Accidentally, these are his words, not mine. I wish I could do them with his accent. Accidentally born in Tasmania. Mum and Dad were in Melbourne. Dad was in the diplomatic corps. Came to Tasmania to visit extended family. I came prematurely to the Royal Hobart Hospital, and puts his arm around me in London in front of his team and says, "We Tasmanians need to stick together, don't we?" For sure we do, Sir Charles. For sure we do. Isn't that a great? We love that sort of stuff, don't we, Tassie? Oh, it's so great. Sir Charles, in his public statements, has said just just as Mark Weinberg, General Brereton, and also Sir Terence Arnold and Sir Geoffrey Palmer, who conducted the Burnham inquiry in New Zealand. We would rather take national responsibility for these allegations than have the International Criminal Court in The Hague do it. It's a pity, in my view, that it takes the existence of the International Criminal Court with its jurisdiction over the Afghanistan situation to provide that incentive. It's a shame that we don't have the commitment in principle to investigate allegations of our own armed forces without it. But the fact that it's happened, in my view, is a welcome development. And from the perspective of the prosecutor, who said this publicly a number of times, he is delighted when states parties or non-states parties take seriously their international legal obligation to investigate alleged war crimes by their own, because the ICC cannot do it all. And we're engaged in a collective commitment to international criminal justice that requires states to take their responsibility seriously. Thank you very much. Didn't give you 15 minutes. Judy, lovely to see you again. Thanks for coming tonight.
Thanks, Tim. Well, that was absolutely fascinating. Thank you very much. Absolutely riveting hearing the sort of about the innards of where you work and the way that it functions. It's maybe a fairly sort of naive question. So I'm really following on. I think I just need to understand what you said. If Putin is found guilty of war crimes but cannot be brought to the Hague in a sense you cannot prosecute him, while you can't bring him to the Hague only in the early stages, what chance is there of his prosecution before the war is actually over, after which you cannot prosecute him?
Firstly,
it's probably convoluted.
no, it's not convoluted. It's a great question, and it's not naive at all. So thanks for asking it. I'll repeat it for the sake of the recording, and you tell me if you think it's an accurate summary. So Judy's question is, I said a few things about Vladimir Putin. One of them was that there isn't any prospect immediately, short-term to medium-term, of the court gaining physical custody of him, and therefore unlikely that he can be tried for war crimes, what I should have said, was tried for war crimes, crimes against humanity, or genocide by the International Criminal Court. So Judy's asking, well, what's the point then of going through a preliminary process, and what are the prospects that he might be tried while the conflict is ongoing, because when it's over he can't be tried anymore? Let's start with that last bit. Is that a fair summation?
Absolutely.
Great. So let me respond to the last bit. We have in international criminal law, in respect of 4 categories of crimes: the crime of aggression, the use of unlawful, lethal military force, which certainly is the correct category of international crime for the unlawful Russian invasion of Ukraine. But in addition to that category of crime, for genocide, crimes against humanity and war crimes in chronological order in which they appear in the Rome Statute, Article 6, Article 7, Article 8 respectively, what we would call no statute of limitations. That arrest warrant against Vladimir Putin from the ICC is valid for his life. If he dies, if he's assassinated, okay, that's it. The court will terminate the arrest warrant because there's no way that that individual accused can appear in person. But until such time as Vladimir Putin dies, the arrest warrant is good, whether that's years from now after conflict's ended or while it's still going on. Second thing to say is that although the prospects, the short-term to medium prospects are bleak, some people say non-existent, that doesn't mean that the decision to issue the arrest warrant is devoid of value, in my view. Now, Vladimir Putin has to think about where he's going to travel. The South Africans, who are state party to the Rome Statute, are grappling right now with...
They announced today that he's not coming to...
Okay, thanks, Matt. I I was busy preparing for tonight. I didn't watch the news, but when your hand went up, I thought, I know Matt knows the inside story. So, up until today, the South Africans have been grappling with, will we have him at the BRICS summit scheduled for Pretoria in a few weeks' time, or won't we? I always was of the view South Africans would talk him out of coming, because either then they have to have the embarrassment of violating their obligations under the Rome Statute to cooperate with the court, or they arrest him. Whoa, that's a big, big thing for a country the size of South Africa to do in relation to the incumbent president of the Russian Federation, let's face it. So, the easier way to deal with that is, mate, however you say that in South African, don't come. Stay home. So the point is, he has to be careful where he travels. It's a big message to him and to his leadership, political and military leadership in Russia. If the ICC is prepared to go after the president himself, no one is safe from the gaze of the ICC. Second observation is that we can feel as though, there's no prospect of him being taken into custody. The precedent I always think of is Slobodan Milosevic. When the arrest warrant was issued against him by the International Criminal Tribunal for the former Yugoslavia in The Hague, way back in the early 1990s, he was then entrenched in power in Serbia. There was no prospect he'd be taken into custody. And right up until the Dayton Accords in 1995, which he was involved in, no prospect. Even after that, until 1999, when he commenced his ethnic cleansing campaign of Kosovo Albanians in Kosovo, a province of Serbia, his population, his electorate, turned against him for dragging us into a war, this time with NATO, bombing the crap out of Kosovo and Serbia, and the next election he lost. And the deal that was done with the incoming opposition by the EU and the US and NATO forces was, if you want the $2 billion US that you need to rebuild the infrastructure that we've just destroyed, you have to hand him over. If you want the prospect of becoming a member of the European Union, you've got to hand him over. Incoming president said, okay, no worries. And off he goes to The Hague. So that took about 7 years. But for me, it's the precedent. Who knows? At some stage in the future, before Vladimir Putin dies, it could happen. I don't say that it will. I think Russia is a different prospect than Serbia. But it's a possibility. Thanks for the question. Yeah.
You mentioned that there was a big team, the Ukraine team was very big. I'd be interested to know how much of that comes from the Global South, because the Global South sees the Ukraine situation differently from the West. And my other question, I'm not sure, are you saying that when the war in Iraq finished, that Tony Blair and George Bush had immunity from prosecution?
Great, so 2 questions. I don't know, it's greedy to have 2 questions in the time that remains, but the first question is, in talking about the resources that have been provided to the Ukraine team, how much of that is from the Global South? It's a great question, and I really appreciate you asking it, look forward to answering it. The second question is, am I saying that in the aftermath of the Iraq war, and here we're talking about not Iraq's war with Iran during the 1980s, but the war of the so-called coalition of the willing in the invasion of Iraq in 2003 by the US, Australia, the UK and other coalition forces, that Tony Blair, George Bush, I don't know why you missed out John Howard, well, I put him in that troika, were immune from prosecution. Let me deal with the first one, because I think it's a very important question. I know of no country, state party to the Rome Statute, from the Global South that has seconded an expert to the Ukraine team. And I could be wrong about that. I mean, the fact, I'm trying to qualify the statement, I don't know. And I suspect none. And there is no question that the Ukraine effort by the ICC is seen, generally speaking, in the Global South as a Western politically motivated project. And there's some resentment about that. And this aspect of it concerns me because what I think might happen with the establishment of an ad hoc tribunal, if that in fact goes ahead to deal with the crime of aggression, then it will be a Western effort, it'll be funded by the West, and the Global South will say, goodness sake, what is wrong with you people? You're prepared to perpetrate the crime of aggression yourself when it suits you, but you won't stop in your desire to put the Russians away when they engage in it. So I think that's problematic for the concept of a global criminal justice system. Does it fundamentally floor the investigation of war crimes, crimes against humanity or genocide in Ukraine? I believe not, but others would disagree with that, and I accept that there is definitely an alternative view about that, and it should be heard and it should be respected. The second question, I'm on the public record as describing the former Prime Minister of Australia as a war criminal. Because in my view, the invasion of Iraq was illegal. It was without international law justification. I think the weapons of mass destruction argument was cooked up to provide a smokescreen of legitimacy, and it shouldn't have happened. And the consequences that flowed from that decision for Iraq have been disastrous, and it distresses me. There's been no accountability for that. All of those three former leaders, while they were incumbent in political office, and this issue is also relevant for Vladimir Putin, while he is incumbent as the president of Russia, none of them can be tried in the foreign courts of another sovereign state, because we have in international law the concept of absolute immunity for a head of state or a head of government while they're incumbent in office. We also know from the Pinochet proceedings by successive benches of the House of Lords that when a head of state or a head of government is no longer incumbent in office, they are then susceptible to prosecution in the foreign courts of another state because the level of immunity is reduced, and the reduced immunity is for acts done in an official capacity, and you can't use that, both decisions the House of Lords affirm, you cannot use that to justify war crimes, crimes against humanity or acts of genocide. This question of head of state immunity, well, not just the question, this issue of head of state immunity does not apply to an international criminal court or tribunal. The problem for the possible prosecution of any or all of the troika of the coalition of the willing is that the International Criminal Court did not have then and has never had jurisdiction over the situation in Iraq. And that's because of the way the jurisdiction of the court works. A bit technical, I could explain it if I had more time, but I don't need to. Please accept that whereas the court does have jurisdiction over the situation in Afghanistan, it did not and does not have jurisdiction over the situation in Iraq, unfortunately, I think. It also doesn't have jurisdiction over the situation in Syria. And that war has now gone on it's in its 13th year, and the International Criminal Court is constrained, hamstrung, to do anything about the screaming need for accountability and justice in that particular situation. I think we're already past the conclusion time. Thursday is about to happen. Surely it's time to